protected group in question. Thus, for instance, killings of members of a protected group will not satisfy the actus reus of genocide under Article 2A unless the killings are part of a broader campaign that is capable of bringing about the destruction of the protected group as such. This is because all of the paragraphs of Article 2 are forms of a crime of deliberate destruction of the human group. The actus reus of such a crime cannot be satisfied by acts which are incapable of bringing about the destruction of the group as such, and which do not contribute to such destruction. Third, I also recall what has already been said about the evidential weight of the material relied on by the Gambia. It is not of sufficient weight to prove the specific facts that the Gambia is required to prove. The Gambia's claimed eyewitnesses, overwhelmingly in the form of anonymous summary hearsay reports, emanates from residents in camps in Bangladesh and cannot be taken at face value and considered reliable in view of ARSA's influence in those camps and the reasons given by Ms. Laurie and Dr. Staker. Prima facie unreliability also arises from the fact that so many claimed eyewitness accounts strikingly and systematically omit any mention of ARSA, despite the overwhelming evidence of ARSA's widespread presence and activities, and that the fact that the operations in 2016 and 2017 took place in locations proximate to where ARSA was active. Moreover, the Gambia's evidence also lacks weight due to the pervasive anonymity of the ultimate sources of information, and the fact that the FFM reports and other reports relied upon were not the product of a court or court-like process. It is another truly extraordinary feature of this case that not even the applicant, let alone Myanmar or the court, know the identities of the vast majority of the witnesses in this case. Having made those preliminary remarks, I turn now to deal specifically with the events of 2016 and 2017. I begin with paragraph A of Article 2, which refers to killing members of the group. As with all the acts specified in Article 2, the objective of the offence forms an integral element. It is thus the act not merely of killing, to which Article 2A refers, but killing members of the group that must be established. Thus, for an act to constitute killing within Article 2A, the killing must be intentional, namely, causing death with an intention to kill. In the Croatia case, this court held that the term killing in Article 2A does not apply to civilian deaths occurring as a result of the use of force exclusively directed against military targets if the civilian deaths were not caused deliberately. Analogously, it will not apply to the death of armed persons engaged in committing a terrorist attack in the course of a necessary military or security operation, or to civilian deaths during such operations if such operations were exclusively directed at legitimate targets and the civilian casualties were not caused deliberately. Throughout its case, the Gambia makes no attempt to quantify how many of those who allegedly died in the operations in 2016 and 2017 were actively participating in the violence, how many were collateral victims and civilian casualties whose deaths were unintentional consequences of the operations, and how many were allegedly intentionally killed by the security forces despite the forces knowing that they were uninvolved. It is only the last of these three categories that could even potentially fall within Article 2A. Instead, the Gambia merely refers to the FFM's unverified death toll figures and the vague and generalized claim that the operations in August of 2017, quote, directly resulted in more than 10,000 deaths, based only on a reasonable grounds standard of proof, not fully conclusive established fact. This bare statement provides no indication as to the proportion it is said were killed intentionally, despite knowledge that they were not participating in the violence. The Gambia provides no indication whatsoever of how many are said to have been killed in 2016 at all. Even if the figure for August of 2017 were assumed to be correct and reliable, the Gambia does not show, let alone prove, that any of this number were not actively participating in the violence on the side of ARSA, or were not collateral casualties tragically caught up in the intense clashes between Myanmar security forces and ARSA. The evidence presented by the Gambia, even if taken at face value, therefore does not establish any killings within the meaning of Article 2A of the Convention. However, even if the Gambia could prove that a significant part of the alleged death toll amounted to intentional killings, which it has not, those killings would only fall within Article 2A if, collectively, they were such as to contribute to the physical or biological destruction of the group, or were capable of bringing about its physical destruction in whole or in part. While there is no specific numeric threshold in respect of killings within Article 2A, given the estimated size of the Bengali population in northern Rakhine State prior to August of 2017 was approximately 1.4 million, the Gambia's estimated number of deaths would have been insufficient to contribute to the physical or biological destruction of the group, and would have been incapable of bringing about its physical destruction. I turn next to paragraph B of Article 2, which refers to causing serious bodily harm or mental harm to members of the group. Like paragraph A, paragraph B applies only to intentionally causing serious bodily or mental harm. Thus, this provision does not extend to bodily or mental harm inflicted by combatants on each other in the course of battle in armed conflict. Nor does it extend to serious harm inflicted upon insurgents or terrorists in battle or during law enforcement operations. Nor does it extend to unintentional collateral casualties in the course of such operations. In an attempt to advance its claims under Article 2B, the Gambia suggests that, quote, reliable estimates indicate that over 100,000 Rohingya suffered serious bodily harm, unquote, during the operations. Upon examination, it turns out that this headline figure is a highly unscientific extrapolation from tick box survey data drawn from 23 townships around Myanmar, not merely Mongdor, Buthidaung, and Rathidaung, over an unknown time frame with multiple recorded events, possibly all speaking to a single victim, potentially nothing to do with the events in this case. This is not even clear evidence. There is not even clear evidence as to which perpetrators might have been responsible in respect of which offences. In short, it is devoid of evidential value. The Gambia also places reliance on what is termed mental health data, taken from a publication by Fortify Rights, which provides no indication as to whether recorded symptoms said to be indicative of emotional distress come close to the threshold requirement under Article 2B of amounting to serious mental harm, nor are details given of who or what may have been responsible for causing such indicative symptoms. It is unclear and unstated how such reported information proves that the Myanmar security forces inflicted serious mental harm within the meaning of Article 2B of the Convention, and on a scale that was capable of contributing to the physical or biological destruction of any purported group as such. I move on next to paragraph C of Article 2, which refers to deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. As with all other punishable acts, Article 2C applies only to conditions of life that are inflicted on the group, as opposed to individuals. And the conditions of life must be capable of bringing about the destruction of the group. Once more, the general deficiencies in the Gambia's evidence apply here. While there is no dispute that there was fire damage in a number of villages in northern Rakhine State, the Gambia fails to establish that the security forces of Myanmar were responsible for all of the fire damage it alleges, or even most of it. Nor is it accepted that the Gambia has established that the fire damage occurred at a time when each village was still inhabited. Evidence produced by UNISAT, particularly fire detection data in the extracted box, suggests that most fire damage was caused after military operations had ended on the 5th of September 2017. This data must be viewed alongside extensive evidence of Bengalis engaging in fire setting, as well as members of the ethnic Rakhine community around this time. The Gambia has asserted that deprivation of food, medical care, shelter or clothing, as well as lack of hygiene and systematic expulsion from homes are also all measures recognised by this court as falling within Article 2C, and that this has been established. Contrary to the Gambia's submissions, these are not measures that fall within Article 2C per se. First, in the Croatia case, this court made clear that for measures to fall within Article 2C, they must be measures whereby the perpetrator ultimately seeks the death of members of the group. The Gambia fails to show at all how any of these particular measures had as its ultimate goal the death of any person, let alone members of the group generally. Second, restrictions on or deprivation of food must be more than, quote, occasional denials of food supplies, end quote, but must be of, quote, a systematic or general nature, calculated to bring about the physical destruction in whole or in part of the group. It is perhaps telling that the Gambia elected to remove the very section of the FFM dedicated to the subject access to food and malnutrition from its annex of the memorial. It does not support its case. The Gambia simply does not establish that any deliberate restrictions on food, even if they occurred, which they did not, were either systematic or of a general nature, or calculated to bring about the physical destruction of members of the Bengali population. To the contrary, the available evidence shows that Myanmar ensured ongoing access to food despite the temporary disruption caused by ARSA's attacks. This point also bears upon the court's consideration of the Dolus Specialis, to which I will turn later. Third, the Gambia fails to identify any evidence of deliberate deprivation of medical care, let alone any restrictions on medical care that comes close to meeting the threshold within Article 2C. Again, the Gambia cannot discharge its burden in this regard because there is no evidence of any deprivation of medical care that was of, quote, a systematic or general nature. As the FFM noted, quote, the availability of functioning health facilities and services in Rakhine State for all communities is low, with an average of 5 health workers per 10,000 inhabitants. All communities in Rakhine State have inadequate access to healthcare, and that underdevelopment and poor transportation make access to healthcare difficult for all, especially for those living in remote areas. Such limitations on access to healthcare as may have existed were not calculated to target the Bengali group. Fourth, turning to the issue of forced displacement, it is to be recalled that this court's jurisprudence determined that, quote, the forced displacement of a population does not, as such, constitute the actus reus of genocide within the meaning of Article 2C. No one disputes that there was a large movement of Bengalis from Rakhine State to Bangladesh, but that this was not the product of deliberate policy or intent to systematically displace the population into Bangladesh, but rather the inevitable consequence of confronting ARSA violence. In any event, the Gambia does not show that the movement of part of the population to Bangladesh occurred in, quote, circumstances calculated to result in the total or partial destruction of the group, unquote. Fifth, while the Gambia claims that Bengalis were subject to extensive restrictions on movements, this collides with the court's finding that, quote, restrictions on movement, on freedom of movement, may undermine the social bond between members of the group, and hence lead to destruction of the group's cultural identity. Such restrictions, nevertheless, cannot be regarded as calculated to bring about the group's physical destruction, which is the sole criterion within Article 2C of the Convention. The court found this to be so in the Croatia case, even where restrictions were found to be part of the, quote, creation of a climate of coercion and terror, unquote. So far as the Gambia's remaining claims of, quote, extensive restrictions on citizenship, on marriage, on births, education, and livelihoods are concerned, the Gambia has not addressed how any of these alleged acts constitute measures calculated to bring about the physical or biological destruction of the Bengali population as such. To the contrary, the evidence shows that Bengalis have readily been able to marry, procreate, and earn a living in northern Rakhine State. An illuminating adminicle of evidence in this regard is to be found within the Gambia's own evidence, such that 51 out of 55, i.e. 93% of the Gambia's signed witness statements originate from married persons, and that 50 out of 55, i.e. 91%, are parents to children, with on average 5 each. Finally, the Gambia claims that the IDP camps in Rakhine State constitute forcible confinement in inhospitable internment camps. This is plainly incorrect, as Dr. Staker has demonstrated. There is no evidence of any restrictions on freedom of movement, access to commercial life, food, water, or healthcare that threatens the physical or biological destructions of those living in the IDP camps. I now proceed to paragraph D of Article 2, which refers to imposing measures intended to prevent births within the group. According to the Gambia, the actus reus of this paragraph is satisfied by what is alleged to be a high prevalence of rape and other brutal forms of sexual violence. The Gambia claims that such acts impaired the willingness and ability of alleged victims to procreate, both because it affected their possibility of marriage and because the trauma has led them not to procreate. Put shortly, this argument fails for the same reasons it was rejected in the Croatia case, in that there was no evidence that, quote, the acts of sexual violence were perpetrated in order to prevent births within the group. In Croatia, the court additionally noted that for acts to fall within Article 2D, quote, "It is necessary that the circumstances of the commission of those acts and their consequences are such that the capacity of members of the group to procreate is affected. Likewise, the systematic nature of such acts has to be considered in determining whether they are capable of constituting the actus reus of genocide within the meaning of Article 2D of the Convention." Unquote. In considering the consequences of such acts, notwithstanding the seriousness of such criminality, the Gambia's evidence does not show that any of the alleged acts of rape and sexual violence committed during Myanmar's military operations have in fact prevented meaningful numbers from finding spouses or procreating. Despite the Gambia's repeated claims that sexual violence was pervasive, massive, or voluminous, the underlying evidence does not justify the use of these adjectives. The Gambia claims that the number of victims of such violence is of the order of hundreds, out of a population of 1.4 million. Even if proven in its entirety, this figure would still represent a very small fraction of the protected group. In any event, the Gambia does not specify exactly when or where these particular alleged incidents are said to have taken place, or the evidential basis for the assertion. Nor does the Gambia establish by evidence any causal nexus between any alleged incident of sexual violence and the prevention of any births. The Gambia just presumes and then asserts without justification that any and all incidents of sexual assault bore such an intention and had such a result. This, plainly, is not sufficient. If it were, it would mean that every sexual assault would, per se, constitute the actus reus of genocide under Article 2D of the Convention, which is obviously not the case. Mr. President, members of the Court, for the reasons I've given, the Gambia's evidence is not capable of proving, to the very high standard of proof that must be met, that acts were committed that satisfy the actus reus of any of paragraphs A to D of Article 2. I turn now to the second matter that the Gambia must prove to establish the commission of genocide, namely the existence of the dolus specialis, or genocidal intent. Even if it could prove that any of the acts specified in Article 2 were committed, that of itself would not prove that the acts in question were committed with a specific intent for genocide, set out in the chapeau of Article 2, namely the intent physically or biologically to destroy the group in question. This is absolutely clear from the Bosnia and Croatia cases. In both cases, there were multiple instances where the court found that genocide had not been committed, notwithstanding that acts satisfying the actus reus of the various paragraphs of Article 2 had been established. The court found that acts of genocide had not been established and proved because it had not been proved that any of the acts had been committed with genocidal intent. And in this case too, the Gambia fails to prove that any acts were committed with a genocidal intent. First, there is no direct evidence of a genocidal intent attributable to Myanmar. This point can be dealt with briefly. In more than 850 pages of written pleadings and some 8,000 pages of annexed documents, the Gambia presents no direct evidence of any state plan, policy, or instruction to carry out genocide. Even 3 purported defector soldiers who claim they participated in the military operations do not suggest that they, or their fellow soldiers, ever acted with an intent or pursuant to orders or a plan to destroy the Bengali population as such. In an attempt to address this lack of direct evidence, the Gambia distorts the meaning of words of Senior General Min Aung Hlang's regarding an unfinished job and seeks to imbue them with a genocidal interpretation. Professor Talman has already addressed you on the full context and meaning of these words. Consideration of that speech in full given on the 2nd of September 2017, dispels any sensible notion of genocidal intent. While counter-terrorism operations remained ongoing, his words acknowledged the suffering of displaced Bengali people and expressed a desire for their return. The local people, for their part, need to return home and try to develop their region. There are many losses and tragedies in the aftermath of the incidents. Cooperation is necessary to remedy them as quickly as possible, while efforts must be made for regional development. Mr. President, members of the Court, in the absence of any direct evidence of dolus specialis, the Court is once again called upon to engage in a careful and rigorous exercise of examining what reasonable inferences may be drawn from the totality of the circumstances which you find established. Professor Thalmann has already addressed the Court on how this task is to be approached and how a genocidal intent may be established. The submissions that I make proceed in accordance with that methodology. This approach requires the Court to first examine whether genocidal acts alleged to have been committed during an attack on a protected group have been established by way of conclusive evidence. Due to the evidential deficiencies affecting all of the Gambia's evidence that it relies upon, as explained in Myanmar's other presentations, the Gambia falls at this first hurdle. Put shortly, it fails to discharge the burden of establishing the underlying acts from which any inference of genocidal intent may be inferred. If, however, acts falling within Article 2 are found proven by way of fully conclusive evidence, the Court proceeds to the second step of assessing whether those acts form part of a pattern of conduct, that is to say, a consistent series of acts carried out over a specific period of time. Only if fully convinced as to the existence of a pattern of conduct does the Court move to a third step and examine whether genocidal intent can reasonably be inferred from an established pattern of conduct. Mr. President, it is to this second step that I now turn, and the issue of whether the Gambia has proven a pattern of conduct from which a genocidal intent may reasonably be inferred. Notwithstanding that the Gambia bears the burden of proof, Myanmar submits that there are 11 features of the evidence taken as a whole that point away from the existence of any such pattern of conduct. The first feature of the evidence to be considered is the existence of activities of ARSA in the region and the context in which the operations of 2016 and 2017 took place. The evidence shows that ARSA conducted carefully planned and highly coordinated attacks against the Myanmar state and civilians in October and November 2016, and then again in August of 2017, in at least 50 locations across Mongdor, Buthidaung, and Rathidaung. These ARSA attacks involved hundreds, indeed thousands, of participants in the deadly violence and widespread destruction. As Ms. Laurie demonstrated, by 2016, ARSA had evolved into a professional, well-organised group. Its objective was to, quote, gain complete control over northern Rakhine State. IIMM witness testimony confirms the extensive capabilities of ARSA, its recruitment, its training, and the sophisticated coordination of action between regiments, and to the widespread manufacture, distribution, and use of explosive devices. In short, ARSA was a serious threat. It was both necessary and justified to deploy military force to confront such a threat when it commenced its attacks. Accordingly, Myanmar disseminated rules of engagement which are accepted as being consistent with internationally recognized standards to its command headquarters and on pocket cards to its personnel in advance of conducting the operations. Such a step to place limits on the use of military force is manifestly at odds with an intent on the part of the state to destroy the protected group. The critical context regarding ARSA is now fully before the court. To the extent that a pattern of conduct is established, it was one of responsive steps taken to the threat posed by ARSA and its mobilised supporters. The second feature of the evidence concerns the timing of the counter-terrorism operations in October 2016 and November 2016 and August of 2017, not just in terms of when they commenced, but also their duration. First, the operations in October 2016 only began after there had been a series of coordinated ARSA attacks upon security personnel and infrastructure in Mongdor and Rathidong townships. Even though the attacks marked, quote, a major escalation of violence in Rakhine and reflected an unprecedented level of planning, unquote, and caused widespread fear, particularly amongst Rakhine villagers, with 3,000 fleeing their homes, Myanmar's use of force lasted 3 days, the 10th of October to the 12th of October 2016. If a genocidal intent had existed at the time of the October 2016 attacks, as the Gambia contends, there is no reason why the operations would not have continued. Second, there was thereafter no further significant deployment of military force until after ARSA's next attacks in Mongdor Township had begun on the 12th of November 2016, involving the killing of soldiers that was considered by the International Crisis Group to be a further serious escalation. Again, however, the security operations that followed were tightly circumscribed, lasting just 2 days, 12th to 13th of November 2016. Again, if a genocidal intent had existed at the time of the November 2016 attacks, there is no reason why the operations would not have continued beyond the 2 days in November and extended beyond just 11 locations in 2016. Third, the ARSA attacks that commenced on the 25th of August 2017 were far more serious than the previous attacks. On this occasion, ARSA's campaign of violence extended to more than 50 locations and involved many killings of non-Muslim civilians, not least at Kalmansake. Despite this, the significant military operations in response to those attacks lasted just 7 days, the 25th to the 31st of August 2017, and were formally ended on the 5th of September 2017. The Gambia's claim that the timing of the counter-terrorism operations was in the hands of the Myanmar military is untenable. The timing of the counter-terrorism operations was self-evidently dictated by ARSA. ARSA decided for itself when it could conduct its attack, and its attacks inevitably led to an immediate response by the security forces. Myanmar can hardly have been expected to have sat on its hands as ARSA and its supporters rampaged across northern Rakhine State. It is, in fact, obvious that ARSA's attacks of August 2017 were timed to commence just hours after the release of the Kofi Annan Commission's final report on the 24th of August 2017, in order to derail that state-initiated peace plan. Thus, the Gambia's argument appears to be that Myanmar conducted operations for 3 days in October 2016 with an intent physically or biologically to destroy the Bengali population, then did so again for a further 2 days in November 2016 with the same intent, and then waited 9 months until August to conduct operations again for a further 7 days with the same genocidal intent, at the end of which some 600,000 Bengalis continued to reside in Rakhine State. The only reasonable inference to draw is that the pattern of conduct reveals an intent to neutralize the threat from ARSA on each of the specific occasions on which there were attacks by ARSA, and to do so proportionately. Since early September 2017, The threat from ARSA to civilians and to state security personnel has diminished, and accordingly, there have been no comparable military operations. The Gambia makes not a single allegation and has not adduced any evidence of any killings or other serious acts of violence which it claims amount to demonstrations of genocidal intent by the Myanmar security services against Bengalis since that date, more than 8 years ago. The Gambia has no explanation for how or why violent expression of its alleged genocidal intent, said to be underpinned by a deep-seated hatred, simply evaporated after 7 days in late August 2017. I now turn to the third feature of the evidence, which demonstrates that there was no pattern of conduct from which genocidal intent could reasonably be inferred. It concerns security measures undertaken in northern Rakhine State after the 2016 ARSA attacks. Following those attacks, it was widely known that further ARSA violence was being planned. As the International Crisis Group then stated, quote, "All indications are that Harakia al-Yaqin